Hi and welcome to this week's Rewind episode wherein we will be covering some very interesting stories from the Supreme Court, High Court and one from the District Court as well. Don't miss out on knowing the winner of SCC online weekly quiz as that will be announced in the end of this episode. So stay tuned. Let's start with one of the most interesting stories. No death penalty but life imprisonment for Yasin Malik, stating that the crimes for which the convict had been convicted were intended to strike at the heart of the idea of India and to forcefully secede J&K from the Union of India. District Court of Delhi expressed that terror funding should be recognized as one of the gravest offences and has to be punished more severely. In this case, the convict claimed that he had followed Gandhian principle of non-violence and was spearheading a peaceful non-violent struggle, to which the court observed that the convict cannot invoke the Mahatma and claim to be his follower because in Mahatma Gandhi's principles, there is no place for violence, however high the objective might be. To read this very interesting case, do check out the SCC online blog. Let's start with the Supreme Court updates. After dealing with a case where an arbitration award had been passed in the year 1992 and the execution petition was filed in the year 2003, however, much to the court's surprise, the matter was still pending. The Supreme Court has directed the Chief Justice of Allahabad High Court to constitute a special arrears committee to address the issue of the long delay in commercial cases. The court has also directed the state government to consider constituting additional commercial courts in the 4 districts of Gautam Budh Nagar, Meerut, Agra and Lucknow. Calling it a glaring example of frustrating the arbitration proceedings under the Arbitration Act, the bench expressed, "It is very unfortunate that even after a period of 30 years, the party in whose favour the award is passed is not in a position to enjoy the fruits of litigation." In an important ruling on land acquisition, the Supreme Court has held that in a case where on the date of commencement of right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, no award has been declared under Section 11 of the Act 1894, due to the pendency of any proceedings and interim stay granted by the court, such landowners shall not be entitled to the compensation under Section 24(1) of the Act 2013 and they shall be entitled to the compensation only under the Act 1894. Giving clarity over the legislative intent, the court asked, should the state and the public exchequer be made to suffer when there is no inaction on the part of the authority in declaring the award? Let's move on to the High Courts, where the right to claim maintenance under Domestic Violence Act and Section 125 CrPC are mutually exclusive. Delhi High Court observed that the right to claim maintenance under the Domestic Violence Act and those under Section 125 CrPC are not mutually exclusive. That is, the aggrieved person can seek interim maintenance before the magistrate while also seeking permanent maintenance under Section 125 CrPC. Bench expressed that the DV Act is without doubt a piece of welfare legislation to protect the interests of women in a domestic relationship and shared household against not just physical abuse but also emotional and financial abuse. Can organisers of political rallies be responsible for provocative slogans raised by any of the participants during such rallies? In a very interesting matter, the Kerala High Court noted that if a member of a rally raises provocative slogans, the persons who organize the rally are also responsible. If a rally is conducted, it is the duty of the leaders to control the members of the rally. Whether the members of the rally raise the slogan with the knowledge of the leaders, or whether there is any connivance between the leaders who organize the rally with the persons who raise provocative slogans, is a matter to be investigated by the police. To read the whole story, please check out the SCC online blog. If a passenger carries a season ticket on local train but fails to provide an identity card, would he be not covered under the bona fide passenger? While partly allowing the appeal wherein a passenger sustained injuries in an untoward incident, Bombay High Court expressed that passenger producing proper season ticket without identity card ipso facto would not render season ticket improper or invalid unless it is proved that the passenger were using season ticket that was issued in the name of another person. Child suffering from mental illness requires a disability certificate. Can certifying authority insist him to come to the premises of the institution? In a very significant matter, Madras High Court, while stressing upon the right to dignity, expressed that mentally disabled persons are entitled to have the assessment done at their residences for the purpose of getting disability certificate under the Rights of Persons with Disabilities Act 2016. Read the full story on SCC online blog. Legislation updates for this week. On May 27, 2022, the Ministry of Corporate Affairs, in view of transition from version 2 of MCA 21 to version 3 and to promote compliance on part of LLPs, has granted relaxation to limited liability partnership to file E-Form 11 annual return of LLP for the financial year 2021 to 2022 without paying additional fees up to June 30, 2022. New Form CAA 16 has been introduced dealing with declaration in terms of Rule 25A of Companies, Compromises, Arrangements and Amalgamations, Rules 2016. The Central Board of Direct Taxes notified Income Tax 16th Amendment Rules 2022 in order to amend Income Tax Rules 1962. The amendment introduces a Rule 44FA dealing with the form and manner of filing appeal to the High Court under Section 245W1 of the Income Tax Act 1961 against a ruling pronounced or order passed by the board for advance rulings by the assessee or the assessing officer on the directions of the principal commissioner or commissioner shall be the same as provided in the applicable procedure laid down by the jurisdictional High Court for filing an appeal to the High Court. The central government has notified Companies Appointment and Qualification of Directors Amendment Rules 2022 to amend the Companies Appointment and Qualification of Directors Rules 2014. The amendment requires necessary security clearance from Ministry of Home Affairs, Government of India, in case the person seeking appointment to act as director shares land border with India along with the consent. In this week's quiz, we had asked, under the curated topic taxation on SCC Online Web Edition, how many rules and regulations have been mentioned? And the correct answer is 15. The winner of this week's quiz is Jyoti Yadav. So congratulations, Jyoti. Thank you so much everyone for watching and supporting our videos. This is Devika Sharma signing off for this week.